I can challenge it. Let's put it this way.
Does that alter the...
No. I can challenge it, Malas. Kindly, that's the point. Contrary to judgments laid down by this court.
Administration must be only by the minority itself.
As a matter of law, I can't get a degree. I can't be called a university unless I'm incorporated under the Central Act. Now, Malas. Now, where does this provision come from?
Mr. Sibal,
Yes.
please refer to section 23.
Yes, and that
In
was
this case, the proviso will apply.
Yes.
And 22 may not apply. So what happens is, in this case, because it was already a university
Correct.
by a central act, is the proviso which will come into play.
Correct.
And for a period of 2 years, there was hiatus.
Correct.
They could then apply and confirm, or the UGC will confirm their status as a university.
Correct.
And accordingly it will proceed. In this case, because it's more than that, because they were already included in the 7th schedule entry 63.
Yeah. But I'm not in that context.
22 and 23 occupy different fields.
Yes.
22 deals with the right to confer a degree.
Yes.
23 deals with the use of the expression university as part of your name.
Absolutely. I pointed out 23, my lord pointed out 22. But Malas, I have a different argument to make. What my lord is saying is absolutely right. But my argument is, where does 22, 23 come from?
Just read 22(1) again. Once again.
Very well. The right of conferring or granting degrees shall be exercised only by a university established by or incorporated by or under a central act, a provincial act, a state act, or an institution deemed to be a university under section 3 of the of an institution specially empowered by an act of parliament to confer or grant degrees. The question that your lordship should ask yourself is, where does this come from? Where is this provision? What's the origin of this provision? And the answer is 1906.
Institution which is not established or incorporated by or under a central act, provincial act, or state act. The substantive part of 23 says you cannot use the expression university as part of your appendix.
Correct.
The proviso, however, contemplated that there may have been universities earlier which were using the expression university, though they were not covered. They were not.
So you are given 2 years.
You are given. It's a sunset clause.
Absolutely.
You are given 2 years to bring yourself in conformity with the UGC Act.
Absolutely.
This case, AMU is not within the proviso for this reason. AMU had already been constituted and an act of the then Dominion legislature, and which law continued in force after the Constitution under Article 372 of the Constitution. Those laws all continued post-independence. So it continued to be a statutory university. As a university governed by 23, it had the right to award degrees. That's how they acquire the right. But your argument is, without this, they wouldn't have had the opportunity to award degrees. Then you would have had to go back to Allahabad University or some other university as it was before the 1920s.
Absolutely. I'm deeply obliged to your lordships. But Manas, the point really is, and this is a different point, and this really tells your lordships the interrelationship between 1906 and 30. Where does this come from, regulation come from? It comes from 1906.
Referable to 1906 is also implicit in 30, because 30, our court has said, 30, though absolute, cannot preclude the parliament or the state legislature, as the case may be, from making regulations which facilitate the character of the
That's under 1906, Manas.
As an institution of excellence.
But Manas, that's under 1906. TMFI says that also. That regulation is under 1906. That's why, Manas, the absolute right is there, but the absolute right has to be regulated by standards. The absolute right is of the choice.
If you apply the expression administer in a very strict sense, namely that there should be no outsider at all, or exclude you on the ground that, look, there are only 37 out of 180. A minority can never run a university.
No, Maharaj, in fact, it is contrary to judgments laid down by this court. Because this court has said that you can have whatever secular education.
One very important circumstance. You can't read Article 13.
Outsiders. That's correct. No, sprinkling of outsiders. Yeah, so therefore you could have outsiders. You will not destroy your minority status.
The object of Article 30, object of Article 30 is not to, if I may use the expression and don't take it otherwise, is not to ghettoize the minorities.
Yes.
So that, you get other people also associated in the administration. It doesn't detract from your character as a minority. It's to be considered. is that by the statute itself, you have to induct into your court a large number of people who are not minorities. This is as a matter of statutory interdict.
It's all right. But I can challenge it. Let's put it this way.
Does that alter the...
No. I can challenge it, Malas. Kindly, that's the point that I made yesterday. If the statute interferes to the extent that I feel that my right to administration, which is the right conferred under 30, is being impeded, I can challenge it. But I can accept it. So the statute, and Malas, we are not here dealing with the administration. This, Malas, please appreciate, Basha never dealt with the administration. Basha said, I have come to the conclusion that you are not established. The minority has not established this institute. And therefore you can't administer.
Basha went on the establishment.
So you don't have to go into that, Malas. We really don't have to deal. The problem arose that in Basha was, the council argued that assume that I am not established as a minority institution, because the administration is
established and administered disjunctively.
That was the
argument.
That was rejected in Basha. That was rejected in Basha.
Which is that Article 30 does not mandate that administration must be only by the minority itself.
That's correct.
In the sense that the personnel who administer are not required by Article 30 to belong to the minority itself.
Exactly.
What Article 30 contemplates and recognizes is the right, namely the right of choice, the discretion which is given to the minority to administer.
That's correct.
In a manner which they deem appropriate.
Correct.
Therefore, it's not that if you don't have only people of your community,
Correct.
then you risk losing your minority character.
Correct.
Because the choice is yours. You may have persons belonging to your community, you may not have persons belonging to your community.
It's an institution of excellence. There's no doubt about it. But Basha says...
Only one interjection, only one. Something is missing, and therefore. You have placed on record the proceedings of the Parliament, Lok Sabha, dated 3rd September 65.
Yes.
And 6th.
Yeah.
There is one proceeding before that, that is 2nd September, the day prior,
Okay.
which I have quoted, my lord, in my written submission. According to me, is an important piece of, my lord, parliamentary debate, which is not on record. I am not, my lord, imputing any motives. That's all.
Well, your lordship notices, Chagla says quite the opposite on the 3rd of September.
That's true, but we can't.
And he is the mover of the bill also. So what does it, how does it take the matter further? I was only indicating how the reference came about. Contradictory opinions can't be the basis of a judgment of a court. That certainly is settled law now.
Right. You can't quote one part and not.
No, you're right. I'm not disputing that. I'm not disputing what you're saying. Justice Gogai's reference was 3 judges. So this objection that, it can't be referred, Maharaj, is all.
And though Chief Justice Gogoi was sitting on the judicial side,
Yes.
as Chief Justice, his powers are preserved by Order 6 Rule 1.
Yes. And then PM...
If bench consists of the Honorable Chief Justice, it can be.
Why can't 2 judges say refer it to 7 and refer the matter to the Chief Justice?
Anyway, but I'll not reduce the debate to that level. I'm not going to raise that objection. We have addressed your lordships on marriage. I will also
Correct,
lordships.
Initially he did, therefore I...
The matter is too important for us to really
Yes,
the judgment.
exactly.
What I initially
So,
said
we
was,
can't be oblivious of the fact, reference of 1981,
certainly,
tagged on to 11 judges,
certainly. I'm
left open in PMA 5,
Yeah.
then noticed in Justice Gogoi in the referring order of 2019.